Good day, Crime Talk aficionados. We have a great show for you today. First, the lawyer for the sheriff accused of killing the judge says it was heat of passion. Will it work? Donna Adelson needs to get a new defense team. Don't kill witnesses and victims. It's a very simple rule. Bryan Kohberger gets a new trial date, this day in legal history, and our dumb criminal of the day. Let's talk about it.
Hi, lawyer.
Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, hit that little bell for notifications, and yes, you can check us out anytime on any of your favorite podcasting apps. Let's go ahead and pay a couple of bills. Ladies and gentlemen, please go to CrimeTalkSearch.com. Sign up for that background subscription service today. When you do, you are literally going to be able to prepare as many background searches on anyone here in the United States that your little heart desires. And when you do that, you're going to get a report that's going to be sent to you immediately. And it is going to have all types of information that you want to know about somebody. For example, their addresses, relatives, neighbors, associates, jobs, education, social media, and it relates to emails that people have. That is significant. Why does my husband have 7 Gmail accounts? That's odd. Is that what he uses for all of the dating sites that he's on? I don't know. Maybe you would have to ask him if you got the report. You're going to find out if people have a criminal and traffic record, bankruptcies, judgments, liens. Are they a registered sex offender? Those are all the type of things you're going to find out. And guess what? You'll get a report and it gets emailed to you, and it's going to be easy for you to see. And guess what? They'll even send you updates as long as you are a subscriber. Go to CrimeTalkSearch.com. You're going to be happy that you did. And remember, you can cancel at any time. When you've decided you no longer need to know anything else about anybody coming into your life, you can cancel. CrimeTalkSearch.com. All right, let's go ahead and open the record for today, October 9th, 2024. So the lawyer for the Kentucky sheriff who allegedly, we know it, we saw it, we see it in video, but you got to say allegedly, shot the judge, his friend, called the slaying a crime of passion that was carried out as his client was experiencing extreme emotional disturbance. So Jeremy Bartley, the defense attorney for the former Letcher County Sheriff, Sean Steins, said that the fatal shooting wasn't planned and his client's charges should be reduced from murder to manslaughter. The attorney said it was something that just wasn't planned and occurred in the heat of the passion, heat of the moment. Anyway, so the defense says the highest level of culpability should be manslaughter based on the partial defense of extreme emotional disturbance. Now, we've seen the video. Hopefully you've seen the video. It shows Steins shooting District Judge Kevin Mullins 8 times in his chambers, hours after the decade-long friends had lunch. And obviously it was captured on video, this shooting. Now the footage shows Steins with Mullins in his chambers inside the courthouse. And this is back on September 19th. And what appeared to be a heated exchange before the sheriff pulled out his gun and pointed it at the judge's head. Mullins, who was sitting behind his desk, raised his hands in fear and attempted to turn away just moments before Steins fired 8 rounds into the good judge. Now, the video shows Mullins hiding under his desk as the shots were fired, then approached the judge, who was under his desk, and allegedly shot him twice at close range before leaving the chambers, where Mullins, who had been a judge for 15 years, went out to the clerks and basically surrendered. Now, additional footage from inside the chambers, not shown in the court hearing last week, captured the sheriff using his and Mullins' phone to make multiple calls to his daughter just before the slaying took place. Now, the attorney did confirm that police found Shine's daughter's phone number saved in the judge's phone. Like I said, the sheriff surrendered after the shooting, and he said, quote, "Treat me fair," unquote. Now, Steins then told the police they're trying to kidnap my wife and kid. Interesting little tidbit there, isn't it, ladies and gentlemen? What does it mean? I don't know. Anyway, we got to see the video last week at the preliminary hearing. The judge said that there was sufficient evidence for the case to go forward, and obviously the grand jury will decide what charges they deem are appropriate. So we don't have a motive as of yet, but they are trying to suggest that there was possibly some sort of a sex scandal but nobody's really elaborating. Was the sheriff a good guy or a bad guy? Was the judge a good guy or a bad guy? No one really knows. Now, there's a lot of scuttlebutt going on, rumors. We don't like to talk about them, but some say judge, bad guy. Others say judge, good guy. Others say sheriff is the bad guy. And others say sheriff is the good guy. We just don't know. And I'm not sure why the district attorney or the defense attorney didn't try to bring that out in the hearing, for the preliminary hearing last week. Anyway, so Steins pled not guilty to the first-degree murder charge, and obviously he's being held in the county jail. Now, here's what heat of passion is, and then I want to give a couple examples of it. All right? Heat of passion is that something was provoked, a sudden heat of passion, if it caused the injury or the death upon a sudden heat of passion caused by a serious and highly provoking act of the intended victim, affecting the defendant sufficiently to excite an irresistible passion in the reasonable person. And between the provocation and the assault, there was an insufficient interval of time for the voice of reason and humanity to be heard. So what does that mean? It's not a complete defense, all right? Most states, like the attorneys are asking for in this particular case, you've got murder, right? Then you usually have like a second-degree murder. And then you have various defenses that you can throw in there called heat of passion that says, yeah, I did it, but it was so inflammatory, so provoking what the other person did that basically you would have done the same thing too. Now, the classic example they taught you in law school was that the loving husband comes home, opens the door, finds a pair of boots by the bedroom door, finds his wife in the bed with somebody else, and then he goes and gets a gun and shoots both his wife and the man. Heat of passion. Something just provoked of somebody, and that was it. Let me give you an example of a case that I had years ago. I had a client. He was a black gentleman. His girlfriend was a Hispanic woman. The mother of the Hispanic woman did not like my client, the black man. She then dropped the N-word towards my client, whereupon he then punched her in the nose. He was charged with breaking her nose. Second-degree assault. We went to trial, and we said it was heat of passion. We don't dispute that he punched the woman in the nose, but, contrary to popular belief, if somebody drops that word on you, it's not a term of endearment. It's actually quite offensive. At least my client took it as being quite offensive, hence the reason punched the lady in the nose. Didn't get him off the hook, but instead of being a class 4 felony, it got reduced to a class 5 felony here where I practice. So that is an example. It's not a complete get out of jail free card. It usually just reduces the penalty. We need to know what the judge said as to why the sheriff's daughter's phone number was in his phone. Was it for reasons trying to help her escape, get away from the bad sheriff? Or was he good sheriff and the bad judge was doing something inappropriate? We don't know. Somebody knows. You would think the attorney would know if he wants to kind of plant that seed out there and give it to us. More than welcome. If you'd like to come on Crime Talk, more than happy to. We're not hard to find. Check us out. We'll talk to you. Or maybe it's just a good old-fashioned case of the dead guy deserved it, and it's a case of jury nullification if more people think the sheriff was a good guy. Going to be a great case. Can't wait. Next, Donna Adelson needs to get a new attorney. So weeks after Donna Adelson's trial was stopped, the judge has now ordered that the defendant get a new defense team. The court noted that while the defendant retains a presumptive right under the Sixth Amendment to her choice of counsel, the right is not absolute, according to the judge. So now here we are. 3 weeks ago, the Miami woman was prepared for her day in court. Adelson had pled not guilty after being accused of plotting and paying for the 2014 murder of her former son-in-law, Dan Markel. Anyway, this case kind of rocked the Tallahassee area for a decade and consumed the lives of many members of the Markel and Adelson families. But Adelson's trial was delayed indefinitely the same day because it was the day it was supposed to begin, because her lead defense attorney, Daniel Rashbaum, withdrew from the case regarding a conflict of interest. This week, the judge said no to Rashbaum's replacement, meaning that Donald Adelson must find a new defense team. The danger to conflict-free proceedings was not cured by Daniel Rashbaum's withdrawal, the judge ordered. Last year, Rashbaum also represented Donna Adelson's son, Charlie Adelson, when he too was accused of trying to kill, or was convicted of, Markle's killing. So while for months it seemed Charlie Adelson was very supportive of his former attorney representing his mother, well, that all kind of changed. Charlie Adelson apparently reversed course and decided Rashbaum's representation of his mother posed a conflict of interest, and he was not willing to waive that conflict of interest. Now, Charlie Adelson's team leading his appeal efforts argued that if their client was called as a witness, Rashbaum could not question him without threatening their attorney-client privileges. And the withdrawal of Rashbaum became necessary when he engaged in a conflicted representation, falling short of ethical obligations for a member of the Florida bar, the judge noted. So after the turn of events, Rashbaum's co-counsel, Alex Morris, stepped up as Donna Adelson's lead attorney. But guess what? The state said, nope, not gonna do it. So this week, the judge decided that Morris, too, has a conflict of interest and needs to withdraw. So the judge noted upon further consideration of the September 17th record and the in-camera proceedings with Daniel Rashbaum and Mr. Morris, a sufficient ethical wall was not established. Thus, the conflict of interest involving privileged information or communications has been imputed to Robert Morris. The order also barred Adam Komisar's Morris's co-counsel from representing Ms. Adelson as well. And without the establishment of a sufficient ethical wall and the fact that even a third counsel cannot avoid the potential for conflict, the court cannot permit Robert Morris or Adam Komisar to remain as counsel of record. The judge used some colorful similes to explain that removing the conflict of interest was simply impossible. Unimputing a conflict seems implausible as unringing a bell, unscrambling an omelet, or pushing toothpaste back into the tube. The judge also said that Charlie Adelson had objected to Morris's cross-examination of him, and he explained his order that when weighing Donna Adelson's right to choose her counsel with Charlie Adelson's right to attorney-client privilege, with the obligation to maintain a productive and orderly court, the idea is clear. Anyway, Ms. Adelson needs to get herself new counsel. Shocking. I can't believe the court went through this, even allowed it to go up to this point. When you, as an attorney, are representing a defendant and potential witnesses are previous clients, I mean, you just can't do that. It's tough. It gets really, really tough. There's ways around it where if everybody has independent counsel and they all agree to it, that can do it. But once the Adelson son got independent counsel, his appellate attorney, they're like, oh no, this can't stand. And so therefore, they got to withdraw. I don't understand why it was such a big analysis either way. When it comes to ethics, ladies and gentlemen, if you got to go break out the books and try to see if you can pigeonhole your way into representing somebody, you just don't do it. It's just not worth it. There will be other clients. There will be other ways to make a living. You don't need to push the ethical limits. I've said this before. I will say it again. I tell it to all of my attorneys. I've never met a client worth going to jail for, and I've never been paid enough money to jeopardize my law license. Bottom line, ladies and gentlemen. So now a case management conference has been set for December 10th of this year, which gives Ms. Adelson time to find new counsel and that new counsel to get up to speed. Next, don't tamper with victims and witnesses. A man in Missouri is behind bars after allegedly running down his estranged wife and forcing her off the road and into the creek. And the victim's family members say it's because she was going to testify against him in an upcoming rape trial. So Donald Pierce Jr. is currently in custody in the Franklin County Jail on charges of second-degree murder, armed criminal action, and child neglect. Now, according to the affidavit for the arrest warrant, Pierce was behind the wheel of a borrowed Chevy Impala when he chased down a Ford Explorer driven by his estranged wife, Jody Pierce. Now, this was apparently off of Oak Grove Church Road in Franklin County. And the officers who responded about 4:30 p.m. on Saturday to the calls of the crash found the Explorer overturned off the roadway and submerged in a creek. Now, Jody Pierce was pronounced deceased at the scene, and one witness told investigators that she was on the phone with Jody Pierce at the time of the crash, and that Jody Pierce had told her that she was being chased by Donald Pierce, her husband. Two witnesses say that they saw Donald Pierce at the scene and inside the Impala, and his cell phone was later recovered at the scene near Jodi Pierce's car. Ooh, once again, the cell phone getcha, leaving it behind at the crime scene. Anyway, Pierce then returned the borrowed car back to the original owner, and the owner told investigators that Pierce had told him he was involved in a crash. Now, the witness said that Pierce then left the home and was picked up by an unknown suspect. Another witness said that Jodi Pierce had dropped her off at her home around 4 p.m. that day, and while they were in the car, Donald Pierce ran up to the car and jumped through the front passenger side window and began verbally abusing Jodi Pierce. Moments later, the witness said Pierce had run back to the Impala and tried to use it to block Jodi Pierce's car in the driveway in an attempt to get Jodi to talk to him. Jodi Pierce was eventually able to leave the driveway, at which point Donald Pierce allegedly followed her in a reckless manner, cutting directly in front of her car. Throughout the investigation, it is believed that Donald Pierce intentionally used the borrowed car with its front driver's side and rear passenger side to strike Jodi's car, which caused the Ford to go off the side of the road, strike the tree, and overturn and become submerged in the creek. Pierce was also arrested on Sunday, and according to the affidavit, he allegedly admitted to investigators to actively chasing Jodi Pierce when she crashed. He denied, however, striking her car with his car, and he said he did jump into the water to try and save Jodi, but he just couldn't do anything. So he left. Anyway, additional notes in the affidavit said that he never called 911 and never contacted law enforcement in reference to what had taken place on the road. Obviously, he's held in custody, and he's going to have court again next week. Next, Bryan Kohberger is going to get a new date. As you know, we had a hearing in the Bryan Kohberger matter with the new judge at the new location there in Ada County, and they were trying to reschedule it. Clearly, the dates that were previously set didn't work for the court's calendar, didn't really work for the defense, and the prosecution said, hey, let's go. So anyway, obviously Bryan Kohberger, the man accused of killing 4 University of Idaho students, is now scheduled to go on trial on August 11th, 2025, ladies and gentlemen. So, as you may recall, the previous Judge John Judge, ordered the trial to start on June 2nd of 2025 after both the defense and prosecution agreed to a trial date next summer. Trial, like I said, is now scheduled for August 11th through November 7th per the new order issued today. A hearing remains for November 7th for arguments on motions to challenge the death penalty there in Idaho. I think there's about a 99.999% chance all those motions will be denied, but they will create decades and decades of legal issues on appeal. Next, this day in legal history, going old school. On October 9th, 1635, 1635, ladies and gentlemen, separatist Roger Williams was banished from the Massachusetts colony for arguing and preaching that civil government had no right to interfere in religious affairs. Sounds like maybe the whole basis why those colonists left England? Religious freedom, perhaps? I think so. It's almost like that was incorporated into the First Amendment now, wasn't it? And finally, our dumb criminal of the day. Yes, unfortunately, more food crime. We thought we were clear of it for a while. It seemed like we were cutting a break from food crime, but it's back. So this young woman, angry that her Domino's pizza was delivered cold and uncut. I think there is a crime against that. Anyway, the same people delivering the Domino's pizza must be the same people trying to fix CrimeTalk 1. It was supposed to have landing gear delivered 2 weeks ago, and it hasn't even shipped yet. Am I bitter? Am I angry? Yes. Am I going to commit food crime? No, I am not. Just the frustration mounts. When it's all done, I will tell you the whole story. But I digress. So the Florida woman, cold and uncut pizza. She doesn't just blow it off. She doesn't throw it in the microwave. She doesn't get the pizza cutter out herself. Oh no, oh no. She gets in her car, takes the pizza, goes back to the restaurant from her residence where she argued with an employee and then flung the pizza at the employee, missing the employee but damaging the store telephone. Criminal mischief, ladies and gentlemen. Now this all happened about 1:30 a.m. and police say that this all took place, and Miss Ricky Hawley was arrested for criminal mischief, a misdemeanor for the pizza throwing incident. After getting to spend the night in jail, she was released on her own recognizance, and the judge ordered her to stay away from the Domino's Pizza, which is a mere 1.4 miles from her house. I don't know. I just see her driving down there in like some big old pink fuzzy slippers. Why is my pizza cold? I'm wondering if maybe a little alcohol was involved. At least that could maybe explain the complete irrational behavior. But if she was stone cold sober, ma'am, you need to get some help. Otherwise, I see you back as a frequent flyer, as the dumb criminal of the day. All right, that's all we have for today, ladies and gentlemen. Thanks for watching. We'll see you next time on Crime Talk. And remember, the Constitution matters.